So good morning to everyone. This is really a pleasure to be here. And I'm happy to be part and to continue the legacy of this training because yesterday we spoke about negotiation and we spoke about mediation and we spoke about some deep element of building mediation through family relationship and by taking some complex theories. And today we're going to jump into the more complex hybrid of judicial conflict resolution that is also connected to a new model that I wrote about together with a colleague who is also a very famous mediator in Israel. And the model is authority-based mediation. This is a model that may sound like very problematic for people who love mediation. Authority and mediation is maybe the last thing we would like to imagine. Mediation is no authority. But I think that it's important to realize what happened to mediation when the judicial system became very dominant in its development. So my talk is in a sense about the journey of mediation from outside the court into the court by trying to, in the way it changes the way judges work. And when it came out of this process of being part of the court, this new model of authority-based mediation is something that now develops, at least in Israel and in the US. But the core goal of my talk is to speak about judges. Judges and their role in managing conflicts, in encouraging mediation, but also in being conflict resolution agents themselves. So my personal journey in dealing with mediation began at the Harvard Law School, also like our presenter yesterday. I was studying ADR with Frank Sander, Professor Frank Sander, the late Frank Sander, the person who established the ADR movement in the US. And at the same time, I was also studying legal formalism. And in a sense, I'm all the time between the more theoretical inclination to speak about the law and the more practical interest and love to mediation. So this project is about the search for this love. Where is mediation? Is it within the courts? Why doesn't it succeed as we expect it to succeed? So this is where I will start talking to you about my research question. But when I met Paula, soon I will speak about the research, I was beginning to think about the research. And Paula, in a sense, I found in her a friend, a soulmate, a person that really share the same values. And since then, the friendship with Paula, that is part of my research project, became bigger than the project itself. So I really thank you, Paula, for this friendship and for this open heart that you have that enabled me really to step into your kingdom and to Italy overall and to learn about judges, to conduct research with your team, to do quantitative work, qualitative work, and all of this without the language and with your support and appreciation, I think, and it was what enabled this research to develop. So I will present your findings from my research in Florence, and the main presentation will present the final product or one of the products of my research, which is about impact. It's about training judges, and it's a training film that I developed with a simulation center in Israel, with a real director, with a producer, with a lot of emphasis on each little part of it. And my hope is that this film can be also transformed to other culture, maybe to training judges in Italy, in England and Wales, which is another country. And this very, really grand project is enabled because I am working with the support of the European Research Council, the ERC, European Research Council, that supports research that has great potential to transform basic science, that is groundbreaking. And I'm telling this because I think this combination of conflict resolution and judges and thinking about the judicial system as a whole and the way mediators play into it, this focus is very important and is something that we need to have in mind, even if we only do the mediation. I mean, sometimes we get the parties, but what happened before in the negotiation? And what happens to them when they go to court? All these questions are asked by me, and I will begin by presenting the research. So my hope is in the next 40 minutes to present the research briefly and to have some time for questions. Then to move immediately to presenting the training and the first two parts of it. We'll have a short break at 11:45 and at 10:45, sorry, I'm in Israel, in Tel Aviv. And then we'll have the rest of the training. And in the meantime, Paula will jump in and we'll speak about a simple justice project, which is an amazing aspiration to transform the legal system by integrating mediation thinking into the judicial work. So all of this will give us a new perspective about the way in which mediation is part of sometimes, maybe from the legal perspective, is part of a bigger plan and an interest in settling cases. So how do we insert mediation values into this process? So sorry, I tried to control it now. So I'll begin with the background to my research. In the US, in the United States, we speak for almost 20 years about a phenomena that is called the vanishing trials, the vanishing trial. It means that most of the cases, most of the cases, and in some countries, all of the cases do not reach the final stage of adjudication, do not get a verdict, and they are settled or they disappear or they are briefly managed in other ways, and there are not full-blown adjudication, not full processes of trials. So the vanishing trial is a phenomena that really changes the legal landscape. It makes most of what judges do, management of preliminary hearings, settlement conferences, abbreviated trials, and many other forms of judicial work that are not adjudication as we imagined it. And this is a significant change, and mediation plays into it, but not necessarily a very central role in this process. This is a process that is guided by efficiency concern. Systems wants to be more effective, more efficient, and we find that both in the criminal and the civil setting, I will focus on the civil here, but my research does the same, ask the same questions also for the criminal setting. All the systems go through reforms. The Italian system is part of it. You don't have vanishing trials. We'll soon talk about how many trials you have, at least what we have in Florence. But there is the trend of decreasing adjudication, the effort to decrease the verdict, the full process, to minimize the interaction, to shorten the processes, to be effective, to measure. Because the idea is that adjudication is very, very expensive. Adjudication is when we need a lot of resources. We need to spend a lot of expenses in order to get to the stage in which the case is really decided after a full process of evidence hearing. Therefore, most systems are focused in how to give parties something else. And we'll soon speak about what is this something else. So my research began with this insight that there are vanishing trials and that I care about mediation and conflict resolution. And still, it's not necessarily what we see when we look at the number. This is not a real accurate number, but this gives you the background for my puzzle. My puzzle began when I saw that after 20 years I teach mediation, maybe even 30 years, and after I teach many courses about therapeutic jurisprudence, problem-solving courts, community courts, mediation, restorative justice, when I look at the system, there are some few percent of cases that reach mediation, and there are some boutique courts that do community service, and there are some programs of restorative justice and different forms of real mediation. But most of the cases are not resolved, not through adjudication and not through a mediation. So there is a gray area which I really wanted to focus on, to ask, how is conflict resolution? How is mediation related to this gray area? How are cases disposed? How do they leave the system? If we have 100, how is it that today we can speak in the US about trials that are diminished, extinct, that they don't exist? In some places, in some states, we have 0 trials. So my question was, to what extent judges are responsible for it, and to what, and would we like to really improve it and give judges more tools to deal with this gray area and acknowledge their role as conflict resolvers and as an agent of conflict resolution. So my focus was on, I had 3 kind of big work packages in my research. One of them was empirical, to study the phenomena of settlement, to measure it, to have interviews with judges, with lawyers, to realize what is the reality of conflicts. From a normative, prescriptive way, I wanted to improve the activities of judges, to work with them, to build training, to have recommendation for the legislative branch, to have policy papers. And theoretically, I wanted to promote a jurisprudence of conflict resolution. So to speak about the legal system, not only as focused on adjudication, but in this era of vanishing trials, the legal system should focus on values of conflict resolution, on prevention, on enhancing relationship, on trying to educate people to avoid the legal system or to avoid or to prevent disputes. So I wanted also to have this theory penetrate and get into, to have this theory develop in a way that will influence the legal system. So I had a few stages to the research. It is a 5 years research that now I get to the 5th year of it. I forgot to say that a few of my team members, many of them are here with me in this training, and this journey is really unique because you get the possibility to have a team that works with you, that helps you to take your ideas and to test them. And it was a pleasure really working with them and developing all these research questions that I don't want to go into them, but just to tell you that I had a stage in which I was supposed to collect the empirical data and to count how many cases are settled, how many cases are withdrawn, how many cases go to mediation, how many are adjudicated, both in criminal and civil setting. There was a stage in which I was analyzing legal materials and trying to compare legal systems and what they allow or disallow judges to do. And there was a qualitative stage in which I interviewed judges both here in Israel, in England and Wales, and then try to examine the finding and implement them into some recommendation, which you will see today in the training. So one challenge of my research that it deals with, it's a comparative study, and it deals with 3 states with different legal systems, and Italy is definitely the most challenging one, because we have a continental system that is different from the Israeli and the English one. And it is a system in which judges, on the one hand, are more involved, but there is not a very sharp separation between pre-trial and trial. And trials are not vanishing in continental Europe. There are many trials yet, but there are reforms. And in 2008, there was a European directive that encourages mediation. And we have the same phenomena like in other states in which mediation is really taking off and is successful, but is not really significantly changing the legal landscape. So my ordered research plan soon changed to various research questions that were more focused, that I won't be able to go over them today, but I will try to briefly look at 3 of them in order to give you some impression of the findings of the research. So one of the questions I had is, what forms and modes of conflict resolution are enabled for judges by various regulative systems? Meaning that what are judges allowed or not allowed to do, and how each legal system, each legal culture actually encourages judges to do or not to do conflict resolution work. So this was a desk work, a work that requires me to look into the books, into the legal frames that are enabled for judges, but also to look into reforms that each judiciary develops and to understand legal culture. So briefly, I would say about Italy, we have here the mandatory mediation, and also we can say rise and fall. You had some challenges to this format, but you still have mandatory mediation. I put here the project of Paula, and she will speak later about simple justice as something that really changes the system and may also have effect nationally. You have special procedural codes that were enacted to encourage judges to promote settlement and mediation. One unique one is mediation order, the possibility of a judge to order mediation, and Paula really promoted this form. We have a possibility for judges to have compromised judicial proposal, what is called 185 bis. That's part of the law that enables them to give a written compromise proposal. They can invite the litigants. They barely do that, but they can do so, and it can be really significant for encouraging the settlement. And they can also promote negotiation according to the law. Some of the written codes that enable Italian judges to work to promote settlement are not really used But then, I mean, from our observations and our interviews, we understood that the mediation order is used usually when judges are trained to do so. Many judges, or some judges in interviews, indicate that they use a lot the compromise judicial proposals, but not all judges even take these measures and work with them. So it's an interesting culture that is in transition, in which judges experiment with these new forms. Some of them are very much utilized, some of them less, but we can say that there is something happening, and there is a change in Italy that also called for mediation to work with the judiciary to resolve conflict. In terms of the legal culture, one of the interesting things that we found that Italians don't define themselves as inquisitorial, and that the civil system is considered more adversarial. But definitely Italian judges look differently from judges in Israel and England when they do civil trials. They sit on the same level, they're not on a bench. There is an atmosphere of working together with the parties. Maybe ideally this could be, could open a room for more conflict resolution, but we found that judges are less involved in that. But this is the regulation in Italy. In terms of England and Wales, we have a very strong institutional interest in settlements. We have the Lord Woolf reform, the Lord Jackson. From 1998, we have constant reforms in England. And these reforms, including the last one of Lord Briggs from 2016, repeat the mantra that adjudication should be the last resort, and that the judicial system should be focused on management, cost hearings. A lot of the management of the case is done without the judges before the hearing. There are the pre-action protocols in which parties need to indicate whether they negotiated, whether they used ADR, whether they gave a settlement proposal. These protocols are very unique and important for a pre-litigation resolution. And we have a legal culture that is common law. This is the origin of common law that is focused now on access to justice. This is the slogan and the overarching goal of the Woolf reform. And we have a very strong role separation. Judges do judging, they're not involved, they don't perceive themselves as responsible for the mediation or the settlement of the case. And in terms of the legal perspective, England is more formalist. I say more formalist comparing to Israel, that I will soon discuss, in which also the legal rules are perceived as more given for the discretion of the judges and less as an open texture. So England and Wales have this institutional reform, and 97% of cases do not even reach a judge. So we have a very sophisticated management system that makes most of the cases settle or resolve or withdrawn before even reaching a judge. So it's a very developed vanishing trial system. In Israel, we have also institutional reform plans, and the most important change that we had also more than 20 years is the shift of the focus of the trial to the preliminary hearing. Judges were given more inquisitorial roles since the 90s, and they can actively engage in managing a case, in interrogating a witness during the pre-trial, in giving a compromise proposal, in suggesting a concrete evaluation of a case. Judges in Israel are very, very active in this preliminary hearing stage. And we have a few codes, few rules that enable judges both to do judicial arbitration, which is what I refer to here as a 79A, to refer parties to arbitration with a 79B, and to refer parties to mediation. But we found a very rich culture of settlement encouragement for Israeli judges, and the film you will see is about a judge that tries to promote this settlement, and we try to help her by inserting more tools from the mediation toolkit and encouraging this new terrain, new framework in which judges are involved in the pre-trial in an effort to reconcile the parties. We try to make it broader and more significant in terms of the interaction. So the legal culture in Israel is common law, but we have also a lot of influence of continental thinking, a code. When we speak about civil law, we have mixed elements and a very strong role for the judge. Judges are important figures in the Israeli system. We don't have juries, so judges become agents of conflict resolution. This is what we actually viewed in our studies. So in terms of the rate of trials, I'll try to do it fast because I want to keep on time. Part of the question we had is how many trials? And I will briefly show you our research in the 3 research countries. First, in terms of Italy, maybe it will be the most interesting for you. We conducted a quantitative study in the Firenze court. And we took the 2016 year and took a sample from all civil cases. And what you can see is that it is true, the trials are not vanishing in Italy. But when we started the research, one of the researchers in Bologna, there is a judicial a center for research of judicial conduct, told us that 98% of Italian legal cases are adjudicated, and Italy doesn't have a settlement almost at all. And when we looked into cases in Florence, and when we look around, we saw that there is much more going on. So there is judgment. 42% of cases that entered the court finally ended in a decision of the court by a judge. But there were a lot of settlements that were declared and written, documented in the court dockets. And there was 20% of the cases were cases that we call them probable settlement, because you have this section 309 that is based on 181, and judges use it in cases in which judges don't show up to the hearing. For 2 times, they declare this 309 disposition, which means that the case is extinct. And in a sense, we can assume that if in a hearing before the judge referred the parties to mediation.
Forgive me for interrupting, but it's the clients who haven't appeared, not the judges.
Sorry, I didn't put the...
you said when the judges don't appear, you meant the clients. When
the
client,
I'm sorry.
Yes.
Yeah, I just had the... Sure, so when the client don't appear, so they...
Because 309 is when one doesn't appear at hearing when the settlement has been reached. Yes, that's it, exactly. So they can be put back into the settlement, added to that. We don't have news.
Yes, but because we wanted to be accurate and not to say something that is unfounded, because this is the way at least the research should be conducted. So we wrote probable settlement, but But usually you can go back, you can see that they were referred to mediation or were advised to settle, and then you assume that this is what happened. So some cases are just inactive, and therefore they disappear from the system and they don't end. They end because of lack of persecution. And there are some cases that we don't know to say what happened to them. But we can see from the map in Italy, so that we definitely have something going on in terms of the decrease of trials. And we have a lot of activities that call for settlement, and judges make efforts not to reach this final stage of decision. And this is statistically valid, meaning we took a sample. It's not only the cases that Paula, for example, chose, it's from all the court civil files. And this is interesting if we want to encourage mediation, if we want to encourage settlement. One of the things I would call to do is to cross together the data from the mediation centers and the data about settlement, and to know also that this probable settlement, if all of this is because of mediation, I really would like to be able empirically to know that. So it can give also an impression of how do people resolve their cases. So this is Italy. Sorry, I'm not on the right place. And we have, I won't go into it, but we really managed to prove that when judges use judicial conflict resolution activities, there is a greater probability that the trial will resolve in an agreement. And that this involvement, whether it is encouraging the parties, whether it is giving the settlement proposal, whether it's sending them to mediation, when this is involved, so cases are settled, cases get into agreement. So Italian judges were actively involved in various activities to encourage parties to go to mediation. I think Paula will elaborate on it, but our research also proved it in a sense, or can demonstrate it empirically in terms of the differences between the judges. I send you the paper that we wrote about Italy. It was just accepted, and it describes this whole process in detail. So when we look into the other countries, I'll briefly speak about England and Wales. We have, as I said, 97% of cases are not even reaching a judge. So vanishing trial is definitely the case. And when they do reach a judge, usually there are much more judgment, but you can understand, but we found that actually English judges are less involved in trying to bring the parties to consent. They're more involved in cost hearings, management of the case in terms of time schedule. They assume that the parties will settle on their own at the outside, and they don't perceive themselves as responsible for the consent and the settlement of the parties. So they are usually much more focused on procedural aspects and management, and less on prediction or active involvement in encouraging settlement. In terms of Israel, we found a lot of settlement going on. As you can see, the settlement here, we have out-of-court settlement, we have court-approved settlement, and we have other dispositions that also can indicate settlement, meaning voluntary withdrawal can be because the parties settled. So one party decided to withdraw and the settlement is outside of the court. We also have here 79A. This is this judicial arbitration, which is not a full trial. It's a consent of the parties that the judge will decide by way of compromise, it is called, but it's actually the judge will decide, but it will not be considered a verdict. And we have some 8% of judgment on the merit. So we don't have 1%, we're not like the US, We don't have disappearing trial, and not even like England. We still have some cases that are decided, but as you can see, the number is small, and I think will become smaller. In Israel, we manage also to put together the stage in which the case is and the case disposition. So you can see, and I will not describe each disposition, but I want to show you the trend. The first stage, where most of the cases are the stage in which we need the smallest, the very limited judicial intervention. Most cases are disposed before even seeing a judge, and sometimes without even having a substantial intervention of court decision from afar. So the cases in which we had only institutional involvement, you see this first column, are cases in which we found only one judicial decision in a case, or maybe two. It means that judges only decided to close the case or to approve a settlement. They were not involved. So most cases settle without the need of the judge to be involved. The court is sometimes just like a post office, an institution in which parties submit a claim and the other side realizes that they are serious about it, and then sometimes it is settled. So judges are not needed in this stage. The next stage, where there is some involvement of judges, but not yet a hearing, not yet a court encounter, a bench presence. These cases in which there are some motions, there are some requests, some activities in the file that are dealt by the judges, and it is enough to dispose the case. Sometimes it's information gathering, it could be injunctions, it could be many things that help the parties to settle by themselves. And maybe it's a mediation. We don't have exact records at this sample of the rate of mediation, but we have mandatory scheme of mediation in Israel, and some cases that are defined here as settlement may be following a mediation. So the most important part that we were interested in is the pre-trial. You see here that a lot of settlement is going on. And sometimes, at least in some period in Israel, parties would enter first pre-trial, second pre-trial, sixth pre-trial, fourth, like a lot of pre-trials. Parties, in a sense, are caught, or they need to stay in the pre-trial stage until the judge allows them to enter the trial and the evidence phase. So we found that a lot of creative activity is happening in the pre-trial. Some, will perceive some of these activities as problematic because they put pressure on the parties. But we tried in the research training film and in our talks with judges to utilize or to take this opportunity in which the judges meet the parties and they yet don't need to decide, as a creative opportunity, as an opportunity to do something which is different than judging, to give some meaning to the judge as a conflict resolution agent, as a regulator, as a person that takes a broader perspective of the law and not just managing it to the next stage. So you can see that a lot of settlement is going on here. And then some cases reach trial. This is where judges give all their efforts and the system spends most of the money, and this is where really adjudication takes place. And there, if you manage to reach the trial phase, 53% of cases are getting decisions. So we do get adjudication at this case and trials that end with a decision. But we have also settlements going all through the way, even in the trial phase, And we have this red, which is the 79A, the way to conclude the judge in the trial in a certain mode that is arbitration. We can call it judicial arbitration. So we have a rich settlement culture developed here. And I'll move forward, sorry, to say something about this culture. I won't go into it, but it's important for me to say that the film we are going to see is based on themes emerging from Israeli court observations. Meaning, we saw judges doing things. We conducted hundreds of observations, actually, together with students and our team. I sent many seminar students to the court. It was actually fascinating to them. We built a methodology of observation, and we coded the findings. And we found that these themes repeat themselves, meaning there is an emphasis on the opening statement. So each judge has his own opening. We'll speak about it today. We have the on and off the record play. In Israel, judges can decide in the pretrial what is on the record, and they can, with the consent of the parties, conduct an off the record discussion. So it's very helpful for settlement sometimes. We saw them using the lawyer-client-judge interactional triangle, meaning the clients have to be in the courtroom. Unlike in Italy, they have to be in the courtroom. So they many times speak to the client behind, above the head of the lawyer. Sometimes it's vice versa. They use it. They use the fact that the parties are in the courtroom to promote settlement. They use court procedure, meaning what is the next time we'll meet, the costs. They use it in a flexible way to encourage the settlement, and they use also the carryover effect of other hearings. In Italy and both in England, we saw that judges invite only the relevant parties for the settlement hearing. In Israel, 3 cases or 5 cases, or in criminal cases, 60 cases sometimes, because they're also preliminary hearing, are ordered to come at the same time, and they're all in the courtroom. And you have this feeling of a settlement industry, or kind of line in which one settlement follows the other, and I think the parties are influenced from this kind of movement. And we have the practices that they use. We'll speak about them later, but they directly try to facilitate what I call the litigation. It's a concept based on Mark Galanter. It's negotiation in the side of litigation. Litigation, the negotiation between the parties. They use a procedural contract, the 79A that I discussed, and other kind of contracts with the parties. They portray sometimes the legal process as negative. We'll speak about it later. So you don't want to continue. It's better to settle. It's not good for the parties. I advise you to really settle now. And they use some ADR technique. Not a lot, as I imagine, but they use it. And we'll speak about it in the film. So when you look at one of the main questions that I asked, and that is related to this workshop, is the question of what really happens to mediation when it enters the court. Can we really preserve mediation as it is? I feel that in Italy, and from our interviews and our observation, it seems like mediation remains evaluative. Mediation sometimes is transformative in Italy. Mediators like you, that according to my impression from yesterday and overall, take mediation as a very serious process that is very different from adjudication. But in many other places, and especially in the US, there is the phenomena of cooptation of mediation, and mediation not necessarily delivers the same messages anymore. So we spoke about yesterday about the loss of the caucus. So this is definitely going on. I won't go here to overview the different modes of new kind of forms of justice that we have. I want to talk about this process of mediation as closing the introduction in order to be able to move on time to the training and to give one of the main theme that I would like to discuss with you. And this is the question of what happens to mediation when we look at it from the perspective of the court system, and is there a possibility to preserve the value of mediation as something else and not a process that is more and more like arbitration, that has less joint sessions as discussed yesterday, and that is co-opted in a sense, that it becomes more evaluative and more focused on reaching a settlement. I think one of the challenges of the system is to preserve this value of mediation. But what happened to mediation many times when it was annexed and became part of the court is that, first of all, judges incorporated some mediation skills and they try themselves to use conflict resolution values in order to promote settlement. And this, I think, is positive, although we can discuss it later. But another thing that happened to some of the mediations that happen today in the world, and maybe mostly in the corporate world and in places like jams or big disputes, is that a form of new mediation that is more close to the legal process, that deals with legal questions, that works with prediction and with mediators that try to promote a certain outcome that parallels the legal outcome. Those kinds of mediation emerge today, and I think it's part of the necessity of the court and a feeling that, in a sense, people many times appreciate a mediator that is skillful, that knows the law, that can address the complexity of the conflict, and that can lead them to an outcome in a way that will be faster and that will be more effective. So we find that big disputes that deal with questions of billions of shekels and that address very complex legal questions are many times, or sometimes, I think that the court really would like to do it many times, are referred to these kind of new authority-based mediation that becomes the more sophisticated legal solution. So we have this genre of mediation that has some elements of mediation, but has some elements of legal work that is conducted today, that is successful in some places. It is another paper that I sent you and that I would like you really to read and to respond on. But I think these two forms of mediators outside the court that try to work with the law, and judges inside the court that tries to insert some mediation, are forms that are very unique for our era, and that it is interesting to study them. It is interesting to see if we would like to preserve this form, if we would like maybe to improve this system in order to make them less needed. But as far as I'm concerned, and as far as I perceive the situation, I think that if we have the encounter with the parties, and if judges should see the whole picture, they should see also the negotiation that happens outside the door of the court. They should look and know something about psychology and conflict resolution. They should handle the relational aspects of the court encounter while preserving boundaries and still using this knowledge to promote conflict resolution. They can use their authority in a delicate way, in a way that will help the parties to be empowered and to resolve the case even when they reach the court. So this kind of delicate work and hybrid focus will be the focus of the training that I will show you after. I'll wait for your questions. But this is the background for the stage of my research in which I try to work with judges to develop a model for judicial intervention during pre-trial. So I'll speak about it later, but I really want now, if I'm able to see if there are questions and to answer your questions. So one question I can understand, and it is what's therapeutic judging? So there is a movement, a global movement that is called therapeutic jurisprudence, and actually part of the advisory board of it or international board of it. And it is developed, it has been developed by Professor David Wexler and Professor Bruce Winnick from the US. And it's about making the law more therapeutic, more focused on the well-being of the person, and working with legal procedure, legal agents, and legal institutions to improve the therapeutic dimensions of the law. So the movement developed mostly in the criminal sphere, but it has also implication in the civil sphere, and it's mostly implemented today in community courts. I'm not sure you have in Italy community courts. It's courts that are problem-solving courts, focusing on drugs, focusing on domestic violence, and they develop a kind of interdisciplinary, rehabilitative focus that makes judges more agents of change. Actually, one of the judges in this training is also a judge in a community court, and it does it in criminal cases in Israel, in Tel Aviv. But this is a very unique development and approach in speaking about judges and lawyers as therapeutic agents. But unfortunately, it's not becoming the mainstream of how legal agents conduct what they do today, but it is influential. Restorative justice is one form of a criminal alternative that is developed today between victims and offenders. But actually, one of the things we discovered in the research that like the multi-door model of Frank Sander that dealt with civil cases and spoke about hybrid of methods to deal with civil conflicts, today we have the multi-door criminal courthouse, meaning that we have restorative justice, although this is not very frequent, but we have preliminary hearings. Most of the cases do not go to trial, they go to preliminary hearings. We have community courts. In France and in Italy, we have abbreviated forms of trials. We have partagiamento, and we have this kind of a plea bargain trial. We have abbreviated trials. So the criminal sphere in Italy, in France, in Israel, all over the world is not about adjudication anymore. So some doors are more therapeutic, some doors are less. So one comment is the results of the research are very interesting, but what about lawyers? We need to educate the lawyers, not only the judges. I think it's definitely true. And I think lawyers are changing. I mean, at least from my experience from law students, are much more open to learn skills that are negotiation and soft skills, and not as David Hoffman described yesterday. If I wanted to speak about my feelings, I wouldn't go to law school, which was the slogan of the lawyer. I don't want to deal with feelings. I think lawyers are changing. But Paula, you are a leader here and the dean and a president, so maybe you can change it, because the study program of students of law still doesn't require them to take those courses. I think it's crucial for lawyers to have those skills, because this is what they do most of the time, negotiate and negotiate in the shadow of the law. So yeah, I think lawyers are important.
I can confirm. Yes, I can confirm that in our law school, we're working a lot on this. And we've also activated scholarships and legal clinics to facilitate this development, this evolution for the formation of a lawyer and legal expert towards competences which are not only technical, but also relational. If I may, I'd like to take the opportunity to make a few comments and questions, because I've seen that we have 4 Italian judges, who are participating in our workshop. And I think, in fact, if they would like to ask any questions, we'd be very happy to hear them. Well, to begin with, I'd like to underline that the report that Michal and her group gave us on the Italian situation is not particularly on the Italian situation, but rather on the Florentine situation. It's a sample of 400 pending lawsuits in the court of Florence. So Florence is a special dimension as far as regards settlement and management of mediation. So be careful, because we can't make it equivalent to the national dimension, and then nor can we make it equivalent to the whole of the activity of the Court of Florence. The tendency of the research group, and it's very respectable, is to intersect the criminal and civil. And certainly in the Italian dimension, it's very different. We study the ADR and keep it very distinct. One detail that I wish to add and comment upon regards what you said on the need for the judges to look outwards and therefore to see the negotiation, see the mediation. This is in the direction that what Carlo Mastelloni was saying and underlining. I'd like to say that in our country, and I'm speaking of Florence, mediation assumes an importance which is quite distinct from the judicial experience. Mediation is outside. Then the judge has his own instruments to facilitate agreement and settlement foreseen by the code of civil law. But mediation is something else, which is done outside with professional mediators in mediation. And thanks to what the discipline of mediation foresees, there is no communication of information from one to the other, because mediation has to remain private. But maybe what I could add and underline is that part of what you said on the fact that the judge should appropriate certain competences. I don't know if I've understood well, but I think that this is very significant of what you said. The judges could appropriate, not only know when they can send or invite the parties to mediate, but also to know what mediation is, how it is achieved, what are the competences, what are the new forms of dialogue, what is the communication, what is the efficacy necessary in communication and mediation, what attention is to be given to the parties from their point of view, in their interest. And this certainly would be an objective to be reached, and which is very important. And that's why I'd like to end this brief comment of mine saying that therapeutic jurisprudence, therapeutic law, if I may say so, has not got something special. Let's just say that anybody who takes care of people, and in this sense the judges are taking care of people, from the technical point of view, of course, in singling out the law and application of the law, but they are taking care of people. So these people produce an aim, which is the aim of care or therapy. So in this sense, everything should be ethically therapeutical. Maybe we can listen to somebody else. Oh, yes, do go ahead.
No, I saw that there is one comment in Italian, so if you want to translate for me, I will happy to, but I wanted to respond just to say, Paola, that I think that maybe with the right planning and the right administration, most of the cases can really get the real mediation, be resolved before, and even before the mediators, and excuse me, mediators, maybe parties can learn to, and we can educate them to identify their needs, to speak about priorities, to self-manage their behavior in the conflict in order to prevent conflict, and when they happen, to resolve them amicably. But if we have a stage in which a judge meets the parties, one of my messages, especially at this time of the COVID-19, when we see how rare it is to meet each other, but when we meet each other, we wanted to be very significant. So I think when judges meet the parties, it will help them to acknowledge that they are within a negotiation that is going on outside of the court. But their role as agents is to help the parties, first of all, to go on with their negotiation, is to know something about negotiation, mediation, and their role as judges, not as mediators, in helping to make this conflict, in a sense, more tranquil and help the parties get themselves and be able to work outside. Part of our impressions from Italy is sometimes parties are referred to mediation and then they go and settle, because when they get this in kind of call to do it by themselves, and they are sent, sometimes they get already to a point when they are able to do so. So if judges are there and we still have meetings with the parties, so let's think about how these meetings will be significant and will acknowledge the negotiation and conflict resolution dimension of this encounter. The legal aspects remain them, and we will speak about the balance and sometimes the clash between the legal and the conflict resolution consideration. They don't always lead to the same intervention, but not acknowledging the fact that we have parties that have so much more than the legal claim, and that addressing this broad context can help them and us to deal with the case in the best way is losing something. So this is why I think the knowledge about the empirical picture, the knowledge about mediation outside, the knowledge about negotiation and tactics of influence is important, because it is needed. It is people meeting, and they need to have these hybrid, concrete guidelines about how to conduct this meeting in the most effective way. Maybe I will get more questions. I have one question. If the issue of vanishing trial, I would like to know if the issue of vanishing trial, including the issue of limited number of cases that come to judgment in the court of Anglo-Saxon countries, should also be assessed from the point of view of public policy in the socio-economic context. I think that definitely it should address, because part of my claim is that we currently, from a point of view of the point of view of the policymakers, we do not offer the parties, at least in countries which really encourage settlement, like England or Israel, we don't offer them a coherent picture of what is the role of the law and of the court. We don't give them adjudication and adjudication is declining, and in a sense, it is not the product that the system offers. But we also don't offer them a full perspective and a comprehensive perspective of conflict resolution, telling them our role as judges is to help you people to resolve your conflicts, to avoid the next conflict, to look at your broader interest. Judges don't say it, and the system doesn't say it. So the system doesn't give a kind of a comprehensive goal that is the value that the parties should measure the system according to this value. Adjudication is in decline, mediation is not really taking place. And in the meantime, the parties are just drifted. They drift in the system until they're supposed to reach a settlement by themselves. And this is something that should be taken care of a policymaker. There is an interesting example in Canada. We had the research and we spoke about Quebec, and they have in the first section of their civic procedure, a declaration, the goal of the legal system is to help parties reach decisions and get to agreement by themselves and to prevent conflict. And then the rest of the procedure continues. So this is something that helps people get another perspective. Currently, we're just driven by efficiency, but we don't really have a policy serious discussion. So definitely a need to be discussed. So I have one question. It is very important to educate the judge to understand what mediation is about and its role in society to facilitate and encourage mutual understanding and not only aim at getting the deal done. Sometimes no agreement is a success for the mediation because the parties have had the opportunity and being able to speak and understand one another. I agree. I have a question. Do you mean that in authority-based mediation, judges are more active in mediation process, meet parties and mediate? So authority-based mediation is conducted by mediators, and judicial conflict resolution is conducted by judges. They're very different, but I was just saying that there are parallel, there is some interchange between the processes, because judges many times refer complex and big conflicts to authority-based mediation, where the mediator is sometimes someone who knows the law and gives the parties a proposal that is based on the law, and still utilizes the other elements of mediation to help them reach an agreement that is broader than the legal perspective. It's not even that. I mean, one example that we had is an environmental conflict we had in Israel about a climate disaster that was causing damages to both preservations, to communities, there was a class action, there was a tort action, there were many cases and conflicts that dealt with this climate disaster in the south of Israel. So this case was finally mediated with multi-parties and millions of dollars for the gas company that had this accident, that was responsible for this accident, but actually it wasn't the company, it was some other part that conducted the work. This conflict was so complex, and so polycentric in a sense, with many centers, and could not be resolved by a court. So, and this was authority-based mediation, meaning that some cases today, legal cases that are complex, that the information is enormous, that the regulation questions are also very significant, that one party is dependent on the other. The insurance company will collapse if the airline will collapse. I'm speaking now maybe about corona damages, but the COVID-19, some conflict cannot be resolved today by court decision, because we need to bring all the stakeholders together and to have the law in the background, but work together to create an agreement in which everybody gives up on something, but the whole arrangement could not hold until we do the negotiation. This is not something a judge can do. And this is something that we can do in a format of consensus building. And in Israel, at least, we had a few examples that did so with authority-based mediation. So mediation is not always the substitute. Sometimes it's the main gateway to resolve a case, because you cannot really deal with a binary kind of yes or no, a legal right perspective with many cases today that are complex. And I'm sure that after this crisis, we'll have many cases that will require this sophisticated mediation that is maybe different from the evaluative mediation we are used to. And maybe we need to elaborate it to be more with elements of mediation, but it is a mediation that is closer to the law and that can be very successful if we take it seriously and can be preferred on a legal outcome, because a legal outcome cannot get and cannot deal with such complexity. I lost the, okay, more question. I'm a student, okay. So if you will forgive me, in order to be on time, because I'm already not on time, I will start with the training, and later I will address more questions. So just to say that my training is based on looking on the practice, trying to come with my theory, and go back to the practice to try to improve it. And since I was debating and discussing this training both with a training center in Israel that does simulation usually for doctors, and we both were in touch with the judicial unit for training in Israel that is located in the Supreme Court of Israel that you saw the library, it's all the time on the background of my slides. So we realized that judges will not be trained in simulation centers like doctors, deal with patients, and that we need to have a film. So you will get highlights of this film, and the film is actually based on the findings we had from the observations and based on a real case, a case that we changed. And the film is divided into 7 parts that are the sections that I will screen to you. And we will work through the 7 parts. Some of them will dig deep. Some of them will just see them and go over. I was giving this training this year, actually last year in November, for judges. It was great. It was 1 full day, and next year I'm going to give it for 2 more days. So Israeli judges here are invited. Here we have a taste of it. And I would really hope that this could be used in other places. It really fits the Israeli system. I'm sure Italian judges will feel that is very, very maybe unfamiliar. And maybe for mediators, it would be weird also to see a judge working in that way. Not everything that is done there is the best practices. We try to have some mistakes. We try to insert places in which I will ask you, what do you think about it, and think how to improve it. But it's supposed to encourage us to think about this unique moment of trying to mediate in the shadow of authority. And it's divided according to the following themes. We speak about before the hearing, what happens before the parties enter the court, and what is the role in preparing for the hearing. We have the opening statement. These are the 2 things we'll see now. We'll have the judge settlement work in advancing litigation, advancing the process of negotiation, but which is outside the court, but also the negotiation inside the court. We will have the reference to the clients and the litigants in the courtroom, together with the question of emotions. I know that in Italy, usually clients are not present, but they can. The judges don't use their authority to invite them to the hearing, and we can see what is the meaning of the parties in the room, how much it is relevant for mediators to think about it. We'll speak about relationship between the legal and conflict consideration, the tension between the role of the judge as deciding by law and the other conflict resolution interest consideration that are relevant, and sometimes they can get us to different outcomes. This is where Paula will step in and will teach her, will speak about the Simple Justice Project and the way in which judges are educated to refer conflicts to mediation. And finally, I can give you the spoiler. No, I won't give you the spoiler, but we'll hope for a happy ending by the end of this session and getting to yes, of course, getting to yes in the courtroom. So I will begin. And overall, I would just like to mention that there are two overarching conversation or axes that I can describe as going throughout my presentation. I have a theory about 6 principles, theories, foundations of conflict resolution. I will briefly discuss them in the end, but I will use them while we see the films, and you also have a paper about this. And I have, and we have the ethical questions that are also intertwined, and they are part of the debate all the time. So ethics of this activity and the relevance of conflict resolution will be guiding us. So this is the beginning. I'll try to press. You hear it? Just one comment. The case is a bit complicated in terms of it's a real legal case, and we have inserted explanations and descriptions both in Italian and in English, and we have subtitles in Italian and in English. And I think you should say, the participants, if you are more comfortable with reading the subtitles or with getting also simultaneous translation to Italian or to English. We were really not sure about it because there is a translation. Maybe we will start with without, and then you say we can add it because, and for the Israeli judges, I circulated in advance a Hebrew version of the description of the case. So. Do you hear it?
בלי צלקות. תן לי לנהל את זה.
אני ביררתי לשופטת הזאת. אומרים שהיא מבינה עניין.
כן, כן, עם אלה שמגיעים מוכנים. אתה זוכר שאני אמרתי לך שהשופטת תלחץ עלינו להתפשר? תישאר קשוח, לא להסכים. יש לנו קייס חזק, אנחנו הולכים איתו עד הסוף.
מה קורה, גבר? מה העניינים? מה העניינים? טוב? בסדר. אני חזק. כולם תומכים לך.
בהצלחה, אברהם.
בלי עצבים.
בסדר. אני מקווה שתראה לך הצופים האלה מכאן צודק.
מי הנוכחים בבקשה?
הטובה אחד, מר אברהם ברקוביץ' בשם כל הטובים.
וגברתי?
עורכת דין צילה כהן.
הנתבעת?
הגברת הקפת בנימין בשם כל הנתבעים והמנכ"לית של חברת הניהול ואני עורך דין ציון לוי.
בית המשפט?
Okay. Was it clear? You got it?
Yes.
Okay. So I'll say a few things about before the hearing and then we go for a break. Oops, I'm sorry. Yes, I need the next slide. Just a few things. I think one of the interesting aspects of this project is, you know, the whole introduction I gave you about the track of a file until it reaches a judge. It also means that when a judge gets a case, he usually knows what happens before. And he knows the empirical aspect, or maybe should know, and have the parties try to settle before. His preparation for the case in terms of knowing exactly what the claims are and have they previously tried to negotiate or mediate is very important. There is a way in which when we think about getting into the meeting with the judge, we would like to make sure that anything else is settled. Meaning that we have all the information, that all the parties will show, that all the missing elements that sometimes are just, they don't enable us to really negotiate, that we take care of them. So one of the things we noticed that if the parties reach the hearing after all the information was gathered, after it's clear everybody is there, after they tried mediation, after the judge maybe send them a proposal or a deadline or an idea about to negotiate or saying, clarifying things about the case that are procedurally relevant. So when they reach the judge can then be involved in a significant way. Otherwise, many hearings, actually it happened to us to have very small portion of observations in Italian courts. If parties are there, it's really important that the parties and lawyers, it's very important that there is a meaning to the meeting and there is a goal for it. And I think preparing for the hearing is in a sense knowing what is in the case and whether it's ripe for an intervention. And also acknowledging the fact that parties, and especially lawyers, come with their own resistance, with their own strategies sometimes of, you know, be tough, don't try to, you know, don't listen to the judge or try. So, and also come with many other interests that the judge doesn't know about. So preparing for the hearing and making the preparation for this first kind of appearance and first impression of the judge, I think is very important, because I think basically we speak about the conflict awareness of the judge, knowing where the file is within the expected track, within the efforts of the party to negotiate, planning how to intervene, how to change something in their interaction. I think it's a very important element that most of it really is before, most of the preparation is done before we see the parties. And we are entering the hearing. So I just want to remind you the background. We have a civil case. The case is about a contract. The contract is where Rakefet, the woman, is a very rich woman who purchased a soccer group, a football group, and she was committed to pay all the debts of the company. Now, the claim is that she's not paying. Avram, the guy there, is very upset with it. He has to take out money from his pocket. And as you saw in the beginning, they're very upset and they are pissed off. They're angry about each other and they don't want to settle. So this is where the judge comes in. Now she will enter the court. We discussed yesterday the opening statement in mediation. And we have a very serious question of whether there is an opening statement art for judges. But I want you now to look at the film and to write to yourself or to think to yourself, what does the judge do? How does she open the case? And how is the way in which she speaks affect the parties? Okay, so this is now the entrance of the judge into the room, into the courtroom.
בית המשפט?
אפשר לשבת? בוקר טוב, עורך דין לוי, בוקר טוב, עורכת דין כהן, מה שלומכם? תודה, גברתי. טוב, אני קראתי את כל מה שכתבתם. הסכם העברת הניהול בקבוצה כלל את ההסכם העיקרי ב4 נספחים. בנספח ג' אתם פירטתם את רשימת הנושים הידועים וכללתם בסעיף כ"ג סעיף של חובות לא ידועים, בסך 276,450 שקלים. סכום ספציפי, הייתי אומרת. השאלה איך הגיעו לסכום כזה? האם ניצלתם את הזמן שעבר כדי לדבר ביניכם? משום שנדמה לי שיש בסיס לדבר.
גברתי, הנתבעים התחייבו לפרוע את חובות הקבוצה, הדבר נאמר במפורש בהסכם. מחירת הקבוצה על חובותיה והכנסותיה. כל אחד מרכיבי סכום התביעה, כבודה, מפורט ונתמך באסמכתה.
עם כל הכבוד לחברתי המלומדת, אם הזכרת את ההכנסות, הרי שעשיתם איתנו חוכא ואטלולא. מהכנסות צפויות של 2 מיליון שקלים, נשארנו עם הכנסות בפועל של פחות ממיליון.
בינתיים מרשי הם שמשלמים את חובות הקבוצה, בניגוד גמור לנאמר בהסכם, וזאת גם לשיטתכם. כבודה יודגש שטענות התביעה שכנגד נוצרו רק לאחר שאנחנו הגשנו את התביעה, וזאת לאחר חילופי תכתובת ממושכים מאוד.
טוב, לצעוק גם אני יודע. אם אתם הייתם עומדים בהתחייבויות שלכם, לא היינו כאן היום.
Okay. So it's not simple to conduct a conversation here, but there is this Zoom reaction possibility. Maybe if you can just sign. Did you like the way she opened the case? How do you put your thumbs up or no, you don't, you only have you can't say no. Maybe you can just nod or say if you liked it or not, or maybe someone would like to say something about the opening. Anyone wants to say, what do you think? What did she do, and did she manage to, how did it affect the parties? What do you think about the opening?
Well, it's simply, as usual, a very aggressive opening.
Why? I mean, aggressive because she, on the one hand, she was smiling, right? She smiled, she looked at the parties, she said good morning, but then she jumped immediately to the case, meaning she wanted to show her seriousness. So in that sense, she tried to be professional and she wanted to show the lawyers that she read everything and that she knows exactly what happened in page this and that in this section. So she came to the hearing prepared. She wants to promote the settlement. She is not here for them to talk or tell her something from scratch. She knows, she's prepared. So she wants to show she's professional. But what happens when she opens in that way? How do you think it affects the parties and the whole atmosphere in the court? Anyone wants to say? Maybe? So maybe at least the way I perceive it, and it will be great to reflect later. I think it, in a sense, first of all, the parties are in the room. So she loses the parties after she opens in such a way. Because they,
well, in Israel, the documents which are given to the judge are all before that hearing.
Yes, I mean, in Israel, the judges also get all the documents, but the parties sometimes start telling the whole story. So the judge wants to tell them, I read it, I'm prepared, I know what happens in each page, and I have a problem in this page.
But in Italy, that's not the way it is. Because at the first hearing, the judge can't do as you say, because he hasn't got the inquiry. He's only got the summons and some of the documents, part of the documents, but he hasn't got the witnesses, if the witnesses are to come, but he's missing all of the other documents which come afterwards. So they have the first hearing, and then necessarily there's going to be a second hearing, and that's where the judge has to look at the proof, listen to the witnesses, and then at the end he can make a proposal. That's why he can then send into mediation. That's my experience. And I see that there are lots of mediators and lots of judges. Dr. Bar-Ilan Bonacchi.
So I think what I meant is that this process is relevant to the second hearing, maybe in Italy, or to the time in which the judge has all the documents and is now really, he needs to help the parties decide, but it's not that is now missing and say, okay, you will bring this, you will bring that, because this can be done actually from afar. You don't need the parties to tell you next time I'll bring this document or that. So assuming that all the documents here, do you have a different opening that you which suggests? So maybe if you can write.
But I'd like to add that we can't contextualize, we can't imagine this situation in the same way and at the same moment in the Italian trial, because the trials are different. They're two different trials. This is just something to make us reflect upon the opening that the Italian judge could have at a moment when he is faced with the parties.
Yeah, I agree, and I think part of the idea is really to look at the judge as a conflict resolution agent and to ask and to adjust indeed to a different culture if we want it to be relevant. But a very big question that I think Israeli judges will ask as well is whether judges need to give an opening statement at all. In mediation, it's very clear. But what is the self-conscious, explicit declaration of a judge? Usually, a judge enters the court and things begin to happen, but not necessarily he declares, now I'm going to try to help you reach a settlement and make sure you know to make decisions based on. So a very first question is whether you think judges should give opening statement, or what is your imagined opening statement that will give a constructive direction to this process, and that will be better than the one that the judge was suggesting. If someone wants to share with us in a chat a sentence, it could be both in Italian and then we'll ask for translation, or in English, about opening, how should a judge, or how can a judge open a hearing in a way that will be constructive and still will preserve the role of his judicial capacity. And if I have suggestions, I will read. So someone wrote, it seems to me that the judge opened the Pandora box with her question. I think that indeed the judge helped in the way she opened the hearing. She made all the emotions come up, the lawyers get upset with each other, and it was as if she was jumping into the high intensity of the dispute without getting also the parties aboard and without letting them see what is this hearing. Most people still come to court hearings expecting for a decision, expecting for the judge to tell them who is right and who is wrong. And one of the expectations I think we need to set for parties today, to let them know that in most cases they won't get this, a wish being fulfilled, because most judges will help them settle by themselves. So maybe this is something that should be said. So I have here a Torah writing, probably not stressing so directly a critical issue, but showing more the profiles, less problematic, on which the parties could bid something more positive. So I think everything that Lila said yesterday also about techniques of mediation should be considered here. So to emphasize the relationship. You are together in this group, you care for it. We are here to try to settle it. Sometimes to speak about shared interests. And Carlo suggested, but the lawyer need to educate the parties. It is true, but here the parties are not really part of the debate. They are left behind, the lawyers argue, the parties feel very angry or excited, they can't really take part of it. And I think part of the question the judges may ask themselves if they would like to say something in the beginning about the process. So maybe say, good morning, I'm here to help you today to reach a decision. I see that you're all connected with the same soccer group, with the same football group. I'm sure that is the best interest for you to get to a decision. I hope that this will be a constructive debate. I don't find many judges doing it, and it's not part of their practice, but I think it is a question, because if it is a process that aims also to bring in insights from our field, so the judge is intervening in a negotiation that failed between the parties, and the judge is there originally to decide, but now he is in a stage in which he cannot decide. This is a pre-trial, this is a preliminary hearing. So what does he do? He may want to declare about what he would like to do in order also to set the expectations for the parties, to make them prepared and to help them get into this maybe changing dynamics that will occur in the court, assuming that there is a meaning to the meeting of the parties in the court. So I have a comment concerning that the judge has already read document. She could ask something from the parties, right? She could engage the parties from the beginning. She could make the atmosphere softer because there are parties there. On the other hand, we should also remember that she wanted to show her professional involvement and seriousness. And if we spoke yesterday about trust, she wanted to show that she is ready for doing her job. She read all the documents. She won't speak now about relationship or about identification or mirroring or things we discussed. She is going to be a judge, and therefore she wants to know exactly what is missing for her in order to decide or to help the parties resolve the problem. But indeed, I think it is a debate when we train judges, most of them really resist the idea of thinking about an opening statement, but it's something to consider. It's something that we would like them to think and to frame from themselves. Some do it with all heart and they really perceive themselves as conflict resolution agents. I think some of them are here in the training, but many other judges think that the hearing is a hearing, but you don't really need to say something that is self-reflective.
Miki, just a minute. I see that Luciana Breggia wants to tell us something on this opening. Hi, Luciana. Luciana is one of the judges who knows a lot about how to open hearings, and so she knows how to facilitate the pursuit of a settlement or agreement. Luciana, do you want to take the floor? Hello, can you hear me? Can you hear me? Can you hear me? Yes. Now, forgive me because I haven't followed very well, because I had the translation overlapping with the original voice, and then I'm here at the office and I was disturbed. But I saw the slides, so I'll be going back to them and I'll be very happy to. At this point, what we were talking about opening, I think is very important. Now, I don't know if I understood well what's been said up to now, but in my experience, the fundamental thing is to establish a climate of trust with the parties and with the defenders. So the fact that the defenders and the parties realize that the judge anyway has studied the written documents, and the hearing is oral, of course, but it has to be prepared by written documents. So, and this takes place at the first hearing. If, as often happens, the defendant comes up before, else it can take place at the second hearing. What is fundamental is that there be a moment when the judge makes the parties understand that he has studied, and that he makes a sort of paraphrase, let's say a summary of the positions, of the different positions of the parties as they've been exposed. Of course, he has to let fall any polemic, any controversial point. He has to be as aseptic, as linear as possible. And he has to say to the parties, if I have understood correctly. This little phrase is very important. It's very important to make the parties understand that I look at them, but from what they've said and from what they've written, I want to be certain that I have not misunderstood, that I have not omitted a reading of a document maybe. So this is an opening, an initial opening, and it produces trust, because trust is the fundamental ingredient to have a good hearing. And upon this, we can set up the request, and I say, I understand this from what you have written, but I'm here to understand your point of view and to go deeper into your point of view. So I usually give the floor to the parties so that they can expose their point of view and go deeper. This is the position. You want the resolution of the contract, the purchase of the house, but the judge can try and see if he can have emerge with discussion and with free questions, see emerge the reasons, the motives for the controversy. What are the interests? Because I think it's a consolidated experience that the positions of the law hide interest. Let's say it's like the tip of an iceberg. There's what's below regarding the needs of the parties, which usually are deep down in the facts. So it's important that the judge not only have a picture of the controversy from the legal point of view, but after having interrogated the two parties and also the defenders and being as serene as possible, he has to make emerge the actual context of the facts. This allows an initial opening, which in my experience is profitable and productive, especially if this cooperation can start taking place with the defenders. Thank you, Luciana. Okay, go ahead.
Michal, we also have a comment by a judge in Israel, Shmuel Melamed. He wrote a comment in Hebrew. A judge should ask the parties what the dispute is about and not tell them what the dispute is about, as was done in the film.
Okay. Thank you. And thank you for the comment. I think it's fascinating that it is cross-cultural and it is something that is relevant both in Italy. I think we learned also that in the mediation order that judges give in Italy, they really go deeper as you describe. And going deeper is an art of conflict resolution. And this is something that happens in the court sometimes, because you see the parties, you ask them, and Israeli judges can also ask judges, what do you care for? What is important for you? And then you realize different things as in a process of mediation. It's not the same process because they came with a special cause and claim, but it helps to give more kind of possibilities and a thick layer in which the complexity may enable now more resolution than before. And I think a judge that can utilize that can talk to the parties, that can listen and not necessarily come with his own narrow kind of look at the document, may reach very important conclusions. I know that there are comments in Italian that I can't read, but if maybe I will, if you want, I can reach it later and maybe you can send it and it can be translated. I want to move to the next section because we are short of time, and I call it advancing the litigation. So again, this notion that Galanter dubbed litigation is what happens all the time, actually. It's not litigation that we have today in court. We have the litigation, meaning negotiation in the shadow of litigation. And here, it is court hearing that advances the litigation because it's not yet the trial. It is a preliminary stage. And I want you to look at it and write to yourself, what tactics, what methods, what mechanism does the judge use in order to advance the negotiation between the parties? Remember that they were very angry before, after she did the opening statement. So let's see what she's saying.
אם אתם הייתם עומדים בהתחייבויות שלכם, לא היינו כאן היום.
עורך הדין לוי, עורכת הדין כהן, אני מבקש מכם להפסיק. אתם החלטתם ללכת ראש בראש בתיק הזה? אתם לא מסוגלים לסיים את הסכסוך הזה בכוחות עצמכם? טוב, אני רואה שהסכסוך מסעיר את כולם. בואו נעשה סדר. כולכם מסכימים שלחובת הקבוצה נצברו חובות. אין גם חולק ביניכם שהוסכם שהחובות הם עד לגובה 2 מיליון שקלים. אני מציעה לצמצם את השאלות המרכזיות לשתיים. האם התובעים שילמו חובות הכלולים בנספח החובות בניגוד למוסכם? ומנגד, האם התובעים הפרו את ההתחייבות שלהם להכנסות צפויות בגובה של 2 מיליון שקלים? עורכת הדין כהן?
כן, גברתי. הייתה התחייבות של הנתבעת לשלם את חובות הקבוצה, אף אחד לא התחייב להכנסות, זה היה צפי. האם הם שכחו שבחודשיים עד להשלמת העסקה נכנסו לקופת הקבוצה סכומים גבוהים, סכומים שמשום מה נהדרים מהתחשיב שמופיע כאן?
זה ברור מההסכם. אז איפה הבעיה, עורך דין לוי?
זה לפרוטוקול, גברתי.
אפשר לנהל את הדיון הזה מחוץ לפרוטוקול, אם התובעים מסכימים?
כן, גברתי.
יש לנו הסכמה, כן ירבו.
גברתי, דובר על חובות של 2 מיליון שקלים. ואז התגלו עוד נושים ועוד התחייבויות, ואלה כבר לא דברים שדובר עליהם. לכתוב סעיפים כלליים של חובות, כשהם ידעו שיש עוד חובות ספציפיים, זה חוסר תום לב, וזה כולל חובות שלא מתועדים בספרים. יתרה מכך, הלכה למעשה, הרוכשים שילמו חובות רבים אפילו מכיסם הפרטי. גברתי, זה שקר.
Okay. So I think we have a few things happening. We don't have the time for you to have it through a dialogue, but I will speak about first the first response of the judge, which was kind of a mediator judge, that they both yell. She says, I see this conflict is upsetting you very much. So she does this kind of separating the people from the problem, the externalization of the conflict that we really know from mediation. She helps the parties gather information. She tries to identify issues and set the agenda in ways in which sometimes mediators do, meaning speaking about what are the issues at stake, where do we still need to negotiate, what is more clear, what is easier to resolve. So she has this capacity and she has this authority actually by law to identify the issues at stake. And this is an important and very major capacity of conflict resolution which judges use and uses very wisely. And maybe this is the main influence of the work on the dispute, because when they identify the issues, when they put them in the right order, many times they can know what can be settled and what is still to handle. And sometimes they can know in what topic they need the help of an expert, where is the place where they can deal with themselves, what is the place which needs a legal decision. So we have in Israel, and this is not something that there is in Italy, I think, we have an official record and we have the off-the-record discussions. Many times it is something that judges use in order to promote settlement. And this is why observations in the courtroom were so important, because most of what happens is actually not documented. You can have a half an hour hearing, and then the record is just after speaking with the parties, we have scheduled it for another hearing. And the public appearance of law, the fact that something happens in the courtroom is not documented. So this is why it was so important to document what happens in order to make it more coherent and explicit and not just a kind of a closed mediation room in which things are confidential. We think that the court hearing should not be confidential, that most of it should be on record, not off record, that it is not the same context as mediation, and therefore judges should minimize the use of this tool and try to be explicit and transparent, because this is what court is about. But the transparency is actually about a settlement movement, a settlement promotion. So I see a response from English judge. Thank you from Justice McLeod. She said, in the UK, if you have an early neutral evaluation hearing, that also is off the record, and that is privileged against the use of the proceedings later. Also, it is confidential and not open to the public. I think in England, indeed, we have a very sharp separation. We have preliminary hearing, pre-trials, in which judges are active, and it is confidential, and later it moves to another judge. The situation in Israel where we see the film is unique because the same judge that is now trying to promote the settlement is the one who will decide the case later if it fails. So the need for transparency is bigger because she is now affecting and actually giving the parties cues and ideas and predictions about what she is going to decide. And we find this practice going on in all instances, meaning we made the observations mainly in trial courts, but even our Supreme Court justices, you see that when they hear cases, they give the parties advice about how to resolve them or how do they will expect to decide it in a sense. And they send them back to negotiation. And many times, even the High Court of Justice sends parties to resolve complex issues by themselves and make them only report to the court about their progress. And when they have to give a decision, they give a decision. but the decision is given only after trying to give a lot of hints, a lot of clues, a lot of recommendations regarding the concrete resolution of the case. So this can be considered problematic. On the other hand, it is more like negotiated adjudication, you can call it. It's a prediction of the judge of what is expected to decide, and then with it, expectations from the parties to make their way with this recommendation, whether it's vague, whether it's explicit, and resolve the case after this judicial opinion. So in Israel, we used to have the England situation in which there were like preliminary hearings in which there was a special judge and then the real case, but then parties always waited to meet the trial judge. So they would not settle in the preliminary hearing, waiting to see who is their assigned judge. And therefore, in trial courts, even in labor court, they move today to this model, which makes the judge much more involved in processing the case through combining the legal prediction with the effort to promote the settlement. And many times it tells the parties, based on what I see now, and we haven't yet reached the trial, I can give you, mirror for you, I can give you, reflect for you the legal situation. And he gives them prediction, he gives them an assessment of what is their legal situation. And this incentivizes parties to settle, because if they know that in the evidence phase, nothing new is going to pop out, so they are more inclined to settle. So I will go to the next part. So I just wanted to mention also that the judges uses her judicial authority, first of all, to make the parties relaxed. And, you know, this conflict is really upsetting you, let's continue. But also she can use her authority to keep the parties in the pretrial. She is the one who decides when they reach the phase where they can enter the trial. So there is an interesting situation in Israel where judges, and maybe in Italy too, judges are kind of gatekeepers, meaning that they will decide whether a case will go further. In criminal cases, and I'm sorry for bringing that, because it's fascinating, the same phenomena, we see that almost no case go to trial today. Most of them are settled in the preliminary hearing stage, and judges keep managing the case until it reaches a plea bargain outside the court. So this use of authority is interesting because judges here are in different roles than the usual role. They are in this role of agents of conflict resolution and of gatekeepers that are supposed to screen the cases and make sure that not any unnecessary case goes further. So in terms of the next slide, and then we'll move to Paula, we have here something that you don't have maybe in Italy because usually clients don't come, but I'll show you the two parts in which the clients are present, in which the parties are present. So as judges, some of you have the parties, but not English judges usually don't talk to the parties, and Italian judges usually don't see the parties in the court, not even many in some criminal case. We haven't watched the defendants, but Israeli judges are allowed to talk to the parties, to interrogate the parties, to examine them. And this is the inquisitorial shift I was discussing. So I want you to look at these two scenes. I will show them one after another and say, from the perspective of judge, first of all, what is the role of the encounter, the meeting with the client? What do we expect from the litigant? From the role of the mediator, how is the judge addressing them? Is it doing it in a way that is helpful for the resolution of the case? Would you advise about a different way? So let's see.
הרוכשים שילמו חובות רבים אפילו מכיסם הפרטי. גברתי, זה שקר. היא הורסת לנו את הקבוצה. מפעל של שנים. יש פה אוהדים באולם שיכולים להוכיח. אני מהכיס שלי, אני משלם.
אברהם תרגע, אני ביקשתי. עורכת הדין כהן, זה בסדר. מר ברקוביץ', בוא תקום בבקשה. בוא תספר בבקשה לבית המשפט למה אתה כאן.
גברתי, תודה רבה. אני מאוד מעריך את זה. תראי, גברתי, אני רוצה להגיד משהו בנימה אישית. אני זקן השבט. אני אוהד את הקבוצה למעלה מ-40 שנה. מאז שאבא שלי היה לוקח אותי למשחקים, זה בדם שלי. אני לא איש עסקים, ואף פעם לא הייתי. אבל בשביל הקבוצה הייתי מוכן לתת הכל. השקעתי מהכסף שלי. את המועדון בניתי בשתי הידיים שלי. אז נכון שהרבה כסף נשפך, ולא תמיד ידענו להתנהל נכון, אבל בלי מה שאני בניתי, היא לא הייתה רוצה לקנות ולהשקיע בקבוצה. ובגלל שחשבתי שהיא באה בלב טוב ורצון להשקיע, הייתי מוכן למכור. אבל להרוס? להפיל עליי את החובות שזה בניגוד להסכם? לפגוע באוהדים?
כל מילה בסלע, גברתי.
וגברתי, זה לא רק הכסף. האוהדים מאוד פגועים. יש פה חוסר אמון בין הצדדים. באים אליי הביתה עם החובות של הקבוצה. דופקים לי על הדלת ב5 בבוקר, יש לי משפחה, יש לי ילדים. כל מה שאני רוצה זה לשים את הסיוט הזה מאחוריי.
תודה. אני מבינה את הקושי שלך, מר ברקוביץ', ואני מבינה שיש פה הרבה אמוציות. כולנו נמצאים כאן כדי לעזור ולפתור את הסכסוך הזה. עורך דין לוי, השאיפה היא שקבוצה למעשה תחזיק את עצמה, ומה לעשות, למרבה הצער זה לא תמיד מסתייע, ואז מקובל שהבעלים מביאים את הכסף מהבית. אני טועה?
הכל נכון, גברתי. מרשתי באמת הביאה הרבה מאוד כסף לקבוצה וכיסתה את כל החובות, אבל הפערים מההסכם גדולים מאוד. יש גבול.
I'm going to the other part because I want to show you the two parts with the clients. Okay.
מרשתי באמת הביאה הרבה מאוד כסף לקבוצה וכיסתה את כל החובות, אבל הפערים מההסכם גדולים מאוד. יש גבול. גברתי, מרשתי מבקשת לדבר.
בבקשה, גברתי, כן.
כבוד השופטת, אני הצלתי אותם. אז מה את מקבלת על זה? תביעה בפרצוף? זה כואב לי בלב הדבר הזה. אני מגיעה למשחקים ושומעת שריקות בוז, כללות, ואחר כך כל מיני השמצות בפייסבוק. וזה הכל הוא. וככה אני אמורה לנהל את הקבוצה. זה בנוסף לכל החובות, הנושים, האיומים, כל מכתבי ההתראה שנשלחו. את יודעת, מכתבי ההתראה שנשלחו להם זה רק 10% ממה שאני קיבלתי. גם הם יודעים את זה. גברתי, אני גדלתי בבית של כדורגל. אבא שלי, זיכרונו לברכה, הוא ניהל את הקבוצה, אז ככה יש לי קשר אישי, כן?
מר לוי, אני מציעה שתמזוג כוס מים למרשתך.
אני דווקא רוצה להגיד שהקבוצה במצב יותר טוב ממה שהיה פעם. גם אני השקעתי כספים בקבוצה, וגם הפסדתי ועוד 2 חבריי, אבל אנחנו לא באנו בדרישות. כי אנחנו יודעים שבעסק הזה לא באים להרוויח. אז מה הוא בא לעשות עליי עכשיו? אקזיט?
את גמרת את הקבוצה.
מר ברקוביץ', תשב בבקשה.
Okay. So we had 2 parts in which we see the parties. And the parties, they have the litigants, they have their own personality, emotions, and they burst into the debate with their emotions. And I think in our observations, many times we saw this kind of burst of emotions. And the question is, what should judges do about it? Usually, judges are supposed to be dispassionate. Judges are supposed to deal with the rule of law to decide cases in a reasoned manner. And one of the interesting questions today in the literature is that how should judges address emotions? In some observations we saw, what they do is they offer a glass of water, as you saw. But there are other things that they could do with their emotions there. Actually, when Avram spoke, if you listened, he actually outlined all the interests that he has substantially. in the case. He spoke about what is important for him. He wanted to put it behind him. He exposed himself, maybe in a way that the lawyer wouldn't like, but it really enabled the judge to look into the conflict. If you noticed, I would ask you what about her response, but she said, you know, this is affecting you emotionally. This is nice, but it's not really the most that she could do, because it's kind of diminishing it to say, okay, so you have emotions. He has emotions with a lot of facts in them, and she could mirror it. She could say, I can see that it's really important for you, the group, and I can see that you want to put it behind it. And when we do it for judges, we really work with a mediator from our team that works against Avram and reflects the needs that emerge from his speech, his emotional speech. And also when we have Rakefet, the woman, we can see that if we are not afraid of emotions, sometimes some emotions like anger are good for conflict resolution because it means the parties care. For example, anger is good and hate is bad. And here we see a lot of anger. So judges that know to work with emotions will not be dispassionate, will be emotionally regulating the interaction. So I think part of what we see in this way in which the parties are there is that judges can manage and regulate emotions in the courtroom. Emotions affect the judge's emotion affect the courtroom. We are really in the beginning of understanding the importance of emotions in conflict resolution. We so much focused in the last decades in cognitive aspects, in cognitive biases and in management skills. But we know today from brain sciences that emotions are responsible maybe for 90% of our actions. So it is important to know how to deal with emotions. It's important to learn how to listen, to learn on facts and interests. I think that what we would like to really, what we try to practice with judges after this part is the art of conflict resolution, of interviewing the parties in a sense, listening to the parties. So it has a lot of issues and complexities to discuss, and there is a main question, which is, can judges encourage apology in the courtroom, for example? We haven't observed a real apology, and some judges would say, no, this is not really something that happens in the court. In the court, instead of apology, you get a check, you get a decision, and don't expect to get a real interaction. But what happens if parties do apologize in the courtroom? And in criminal cases, we would like to encourage it and think the whole kind of a discussion of emotions bring forward other practices of conflict resolution to see if they're relevant, and if they're not relevant, whether we can have small gestures, like if one party, and we saw it in an observation, says, well, I'm really sorry for this problem of bringing you this sofa with the holes and that is not functioning. So in our observation, the judge says, okay, let's move forward. When is the next hearing? And from our perspective, taking moments of human expression, of acknowledgement, of possibility of direct interactions between the parties in the courtroom is important. It's something that judges may try to work with and not actually be afraid or just give a glass of water. Sometimes emotions are important and should be acknowledged as part of the process, and judges that will know to work with the emotions and at least to emphasize, this is important that you say that. This is something that I would mention. It's not irrelevant. And some small steps in criminal law of restorative practices, things that reflect some acknowledgement, will really make us out of the all or nothing perception of adjudication, which is not existent today because judges are not in full adjudication. So I would like to answer questions, but it's also time now for Paula.
Sorry, Michael, sorry. I saw that there's a comment by Giovanni Cosi. Maybe we could put it across for everyone. He's a professor from the philosophy of law from the University of Siena. I was thinking, looking at this scene, that there is a certain amount of confusion of role and especially confusion of context. I think that the judge has very good intentions, but the road to hell is paved with good intentions. The context is wrong. The risk is that we exchange justice, technical justice represented by the judge, with social sanctions, because there's a whole room full of people behind them. I'll try and give you a limit case. It's a bit the atmosphere is like fans at a stadium, lynching. That's what the room risks being. The mediation room, and I've heard about it often. I'm not personally a mediator, but I think that the context and the environment are fundamental. So you're trying to do the right thing, but the context is wrong. That's what I wanted to say. Can I add something? Sure. Let's say the premise is that, as we often say, it's not important what color the cat is as long as he gets hold of the mouse. But we have to start from our methodological approaches if we want to give importance to mediation, because either we put everything into the pot, every type of alternative procedure in order to solve controversies, or else we lose the sense of things. We've talked about the double role, the problem of the subject that goes and judges a case and then has to manage the other phase, the previous phase, the attempt for mediation. This is an aspect which has to be considered if we're looking at mediation or settlement. In France, for instance, we talk about conciliation. We had conciliating judges in Italy too. This is a subject who is asked to decide to bring the controversy to an end. But the attempt this subject makes is to help the parties to first find other types of solutions to see if there is any space for negotiation. But we're talking about a different instrument. We can't, in Italy, we can't talk about mediation when we're talking about a subject who then could go and decide upon the case. There are experiences, Dr. Morricone teaches us this, a judge of the Court of Rome, who speaks of guided mediation, guided by the judge. But generally, there is a passage to an organism where delegation is made to the mediation. But it's completely different when the judge is to know the instrument and is asked to have knowledge of the instrument, because obviously if the judge knows well what the institute is, not only from the point of view of law, but he can help the parties to favor a passage into mediation and the solution of the case. Any other comments? Anybody else want to take the floor? Yes, Ettore. I wanted to say there was Daniele, I think, who wanted... No, he's already taken the floor. Daniele Pertelluti has already taken the floor. And also a student. The student's not called Daniele, but Pietro Chiarelli. Pietro Chiarelli, do you want to say what you wrote down before?
Okay.
He said he would have spoken later on. Oh, okay. Miki, what do you prefer? Would you rather answer everyone together now? You choose.
Maybe just shortly, because I want Paola to talk. I think that we're speaking about various and numerous procedures that developed today in many countries. And indeed, this is a unique process that fits the Israeli culture. And I'm sure it will be, even from Israel, for Israeli judges, the way the judge intervenes here may seem unfamiliar and problematic, and in a sense, not what we expect from a legal hearing. But for each kind of these new processes, whether it's reconciliation, preliminary hearing, abbreviated trials, we need to develop a method, a perception, a public perspective of what judges do. And if it doesn't need to do it, or just needs only to, decide, so let him decide. But if he's there in this intermediate role, intermediate phase, not really asked not to decide, told that adjudication should be the last resort, and he should do something. So the question is, what should he do? And it brings me to Paola, because Paola has a view that I think is different from me. And she says judges should be judges, but they should know very well the process which exists outside the court. And they should be educated to identify cases that can go to mediation by ordering the parties to do so with the help of my people who will educate them and train them to do that. And I think it's a different concept, and it's not less legitimate or good. From my perspective, the judge at least should know the landscape that exists, and then should choose whether he wants to go very narrow and refer them outside. And maybe if this is the first thing that the judge should say. But when he has to step in, if he has some skills and some knowledge, so I think it can help him. But I know that this is not, maybe it does not go with each legal culture and the perspective and the directives that exist in each place. So I'm really excited that throughout our friendship and the process of working with you, this project developed so far and is so much spread in Italy. First of all, it's always exciting to see that Italy preserves, the legal culture preserves the dichotomy, and mediation, as I said, is really practiced in the full sense. And I believe that conflict resolution education for judges, for lawyers, is very important. And any way we do that is significant. So I'm truly for it. I actually now try to develop a software that will help parties to identify interest before they see a lawyer. Because usually once the lawyer is there, the picture is becoming narrow. But I think that this kind of language is also about sorting out the forum, fitting the forum to the fuss. And one really important goal of judges is to know when a case is not for them to help. But still, my judge, and Martin, if you can upload it, my PowerPoint again, my judge is an agent in conflict resolution. And I understand that it really, for some of the people, it really evokes a lot of resistance and cultural kind of miscomprehension and feeling that it's not the right. But I still will encourage you to watch, even if it's hard, the next 2 parts, because we're soon getting to an end of this really important, interesting scene of the basketball. And the next part is about the relationship between the legal and the conflict consideration. And you can see there that the judge does things that are really maybe not recognized in other places, meaning she balances the conflict against the legal merit, and she tells the parties what to do with what she thinks about the trial. She speaks about the trial as possible, as you see, not necessarily answering the parties' needs. And since we don't have time, I will, after showing you this part, I will go directly to the end, so you see how it ends. The whole process is a process in which the legal considerations and the conflict considerations are together. There is not this separation. You can see how the judge in her talk is trying to let the party consider whether it's worth for them or whether they would like to pursue the litigation, and then tries to continue helping them to resolve the conflict. So I'll show you the two scenes, then it will end, and I will say my final things, and hopefully we'll have some...
את גמרת את הקבוצה.
מר ברקוביץ', תשב בבקשה. אני שומעת שמערכת היחסים ביניכם היא מאוד משמעותית להצלחת הקבוצה. מר ברקוביץ', אתה אמרת שנשבר האמון בין הצדדים. ממך, גברת בנימין, אני שמעתי שהיחס המיוחד לקבוצה התחיל לא מאתמול. אני בהחלט חושבת שיש מקום להתייחס גם להיבטים האלה כאן, ואולי באמת אחרי שנגיע להבנה של כל הנושאים שמונחים כאן בפנינו, אפילו תלחצו ידיים.
גברתי, אני מבקשת את רשות הדיבור. טוענים הרבה שעוסקים בספורט מאהבה ולא בשביל הכסף. אבל יש כאן שאלות משפטיות שהתשובה עליהן היא ברורה, ואני אבקש שכבוד בית המשפט יכריע בהן.
גברתי, נעשה לי עוול ואני רוצה צדק.
מר ברקוביץ', כולם רוצים צדק, אבל צדק זה עניין סובייקטיבי, כן? כל אחד מבקש צדק, בית המשפט לא יכול לענות לצדק של כולם. בית המשפט בוחן את המציאות המשפטית על סמך הראיות, וככה הוא מכריע. במקרה הזה, אופן ניסוח ההסכם ידרוש דיון בשאלות של פרשנות החוזה. יש פה שאלות שהתשובות עליהן הן לא חד משמעיות. אז בואו נחזור לסדר הדיון שהצגתי בהתחלה. אנחנו דנים בשאלות של היקף החובות, מי שילם מה ומה כללה התחייבות בנוגע להכנסות הקבוצה. כן.
כמו שגברתי אמרה, יש חוות דעת שמציגות בדיוק את המספרים, היקף החובות ביום החתימה, תשלומים שונים שנעשו. גם הם הגישו חוות דעת, שאומנם יש לי לא מעט סימני שאלה לגביה, אבל על פניו שיעור החוב הכללי ביום החתימה זהה.
מצוין. אני רואה שיש בסיס להידברות. נדמה לי שלכולם יש מה להפסיד מניהול הוכחות בתיק. איך שלא נסתכל על זה, ואחרי הגשת התצהירים, מועד ההוכחות יהיה עוד שנה. 3 ימי הוכחות זה מפח נפש.
Move to the next part.
3 ימי הוכחות זה מפח נפש.
מה גברתי מציעה?
אני מציעה שתצאו החוצה ותנסו לחשוב אילו דרכים יש לכם כדי להתקדם בתיק הזה. תחשבו קצת מחוץ לקופסה. מבחינתי הכי קל להכריע, זה מה שאני יודעת לעשות הכי טוב. ואם נצטרך, נוכל להכריע גם לפי 79א. גברת בנימין, אדון ברקוביץ', אוהדים יקרים, אני באמת מציעה לכם לחשוב על עצמכם כקבוצה. אחרי שכולנו נמשיך לתיק הבא, אתם תמשיכו יחד לדחוף את הקבוצה להישגים, אז תהיו יצירתיים בשבילכם ובשביל עתיד הקבוצה. אז צאו עכשיו החוצה ונתכנס פה בעוד 20 דקות.
בית המשפט?
אני בטוחה שניצלתם את הזמן לחשוב על מה שדיברנו פה בדיון לפני ההפסקה. עורכת הדין כהן, תגידי לי בבקשה, מה הכי מטריד את התובע?
מבלי לוותר על יתר טענותינו כמובן. התובעים מוטרדים במיוחד מהחובות שטרם נפרעו, וכן מהחוב הגדול בסך 100,000 ש"ח ששילם התובע מכיסו לחברת ההסעות, כבודה.
עורך דין לוי, אתה שמעת את הדברים שלו. עורכת הדין כהן, מה יש לך להגיד?
מרשתי מוכנה להעביר מחדש את התחייבותה לפרוע את חובות הקבוצה במלואם. לצד זה, היא עומדת על החובה של התובעים להשיב לקבוצה את הסכומים שלקחו לכיסם.
העברה מחודשת זה רעיון מצוין. ומה לגבי החוב ששולם כבר על ידי מר ברקוביץ'?
כאמור, יש סכומים שהתובעים נדרשים להחזיר. אנחנו מוכנים לקזז את הסכומים שהם שילמו. על פי חישוב שלנו, לצורכי פשרה, הנתבעת מוכנה לשלם לתובע סכום בסך של 75,000 שקלים. הסכום הזה אינו נתון למשא ומתן, אחרת אנחנו נדרוש להעביר את הדוחות לרואה חשבון מומחה מטעם בית המשפט, וגם זה כרוך בהוצאות.
גברתי.
עורכת הדין כהן, רגע, לפני שאת משיבה. הסכום שהנתבעת מציעה לא נשמע לי מופרך. אני מזכירה לכם שיש פה ויתור משמעותי של הנתבעים על הטענה בקשר לרווחים שלא התממשו. זו שאלה משפטית מורכבת שיכולה להיות מוכרעת לכאן או לכאן.
גבירתי הבינה נכון. אופן ניסוח ההצעה על ידי חברי קומם אותנו, אך התוכן מקובל עלינו. מרשי ולא בהכרח בברכתי מבקש לסיים את התיק עוד היום, גם במחיר של נסיעה בחובות משמעותיים ששילם עד כה מכיסו.
יופי, אז אני אסכם את ההסכמות עליהן הגענו עד כה. באי כוח הצדדים הגענו להסכמה על פיה לסילוק מלא ומוחלט של התביעה. הנתבעת תשלם לתובעים סכום של 75,000 שקלים עד ליום 30/10. הנתבעת מצהירה שהיא החייבת הבלעדית בחובותיה של קבוצת הכדורגל, ואין לתובעים כל חבות בגין חובות הקבוצה. וברשותכם אני אוסיף, הצדדים ינהגו בתום לב ובלשון נקייה בפעילותם ביחס לקבוצה. אפשר לתת תוקף?
אנחנו מסכימים, גברתי.
בית המשפט מאשר את הסכם הפשרה ומורה על החזרת האגרה.
תודה רבה, גברתי.
שנת משפט מוצלחת.
בית המשפט?
טוב, חשבתי שנהיה עוד... זה הרבה שנים בסיפור הזה, אז...
לא האמנתי שככה יתנהל המשפט. אבל העיקר שהצלנו את הקבוצה,
פגש במגרש.
What I wanted to really emphasize after seeing this film, that this is actually the ideal judge, that is the judge who promotes conflict resolution. This is the judge who is agent in facilitation of agreement, and she really negotiates the aspects that are aspects of legal considerations. And in a sense, she gives a negative, she portrays in a negative way the trial. She says, you don't want to reach the trial. The trial may entail very complicated and very problematic legal questions that you don't want to decide. You should think about the benefit of the group. She tries to speak about the shared interest. So she uses many elements of conflict resolution that are used also by mediator. She uses it in a way that is unique for her as a judge in her authority position. She builds a process. She is looking forward in a constructive way. Each time the parties are emotional or go back to the dispute, she tries to say, okay, I see it's important for you, the relationship. She emphasizes the positive aspects. And she is speaking a little about interest, not all of the interest like mediators, but she speaks about the interest in ending this dispute, in going back, continuing with the promotion of the group, so unique to this conflict. And she also used this complexifying hybridization, the family ties maybe approach that we discussed yesterday when we spoke about the role of the mediator. I mean, she's trying to really to take the relationship and from there encourage the parties to develop relationship, to address emotions and to do it from the bottom up. And it may seem really weird that she asks one of the parties, what is the most important, one of the lawyers, what is the most important thing for your client? But we actually saw an Israeli judge doing that in a simulation we conducted. So when we speak about the possibility of the judge, when the window of conflict resolution opens, I think we have much more possibilities than we can usually think about. And when we think about the fact that in any case, judges they find themselves in this point in which they don't yet decide and they can't yet decide, and still they try to reach an advancement, and the parties are there. So maybe taking this lesson, taking this approach of conflict resolution will benefit their practice. Maybe there will be less and less cases in which judges would need to do so because parties will mediate outside of courts. But I'm just saying that in places today, when we see judges in new roles, in preliminary hearings, many times due to the efficiency concerns and due to really lack of training, we don't find any image or any expectation that is framed for the judges of how they should behave and what are the values that they should pursue. So my proposal is, in a sense, to take this notion of getting to yes and as settlement and consider expanding the discretion of the judge, considering seeing him as an agent of conflict resolutions. So for judges, I think, in all systems, it could be very important to learn about what others do and to consider, even if they are not conducting such and not using these tools, they can consider still to sometimes use part of them or know what happens in other places or in mediation rooms. For mediators that get the files after the court and know that the parties go to court, it is important to know what is going on, and it is important also if mediators would like to exercise authority-based mediation and sometimes play with legal and conflict considerations. And maybe an important thing that also came out in one of the comments is that when we look at judicial systems, and this is one research question that I have today. So part of what we see today is that at present, we have emphasis on efficiency, which is very important, and parties need to get their day and need to get resolution, and we don't want them to really be carried out for long periods of time within the court system. So we see the emphasis on efficiency, but we don't have a very clear formulation of what is the judicial role. So my suggestion is, instead of letting parties draft between this no adjudication and no mediation and just settlement-driven process where sometimes the role of the judge is only managerial, I think we need a system in which there is a clearly defined goal of resolving conflicts, of avoiding them, that gives parties more layers, more doors, more possibility to reach solutions by themselves, by helping to analyze their interest, to think creatively, to check other processes. And then in this system, we really will have more choice, we have more possibilities and the future of the judiciary is, in a sense, taking the whole perspective of conflict resolution and applying it all the way, and not keeping the split between mediators and judges. So part of my efforts here was to start a dialogue between these conflict resolution agents that may share the same goal and at least need to know what happens when each one of them processes a case in order to improve our legal system. So we're not only improving skills for mediators or just improving skills for judges. We are rethinking the architecture, design of our court system, and we're rethinking the values. And my proposal is to take seriously the conflict resolution perspective, not only as an alternative, but actually as a main goal. And think about judicial system as focusing on preventing and resolving disputes. And the rest, each legal culture will need to really shape and construct for itself. But the main idea is to think seriously conflict resolution and to take it to the next level that in any way exists in many spheres and many cultures today all around the world. So this is my my part in the presenting this new model and presenting the research, and I will try to answer questions if I understand them, and if not, I will be happy if you can translate it for me. So what does Professor Alveston think of the risk on the effectiveness of the protection, not only from a legal point of view of this approach attempted by the judge, which can be run by the weaker parts of the process, understood as those with less economic, cultural, legal resources? So thank you. I mean, I think it's a great question. And for this, I have a paper as well, which means that it's so good. So we have a paper about the access to justice and the way it affects settlement. And in a sense, weak parties, disempowered parties, they suffer throughout the legal system in all stages, and both when they are represented by lawyers, and especially if they are not. So it's not that this setting of settlement is the only place where the differences come out. There is a very famous paper of Mark Galanter that speaks about why the haves always come out ahead. And basically it says the haves will have better lawyers, they are repeat players, they can really negotiate whether to settle, whether to adjudicate. And the one shooter, the one player, the weak party, they only have their case. And many times they will find themselves less represented and less power. But a judge in a settlement context, I think, can refer to that, can address that. We shouldn't think that this is actually a place in which injustice and inequality can be re-emphasized. He is an agent as the same way in which mediators are not reinforcing power imbalances and can be effective in dealing with parties that are weaker. So judges should be aware of it too. I think they are. And many times parties in a case where they are the weaker, many times we find institutional players complaining about how much judges are for the weak parties, but this is their role actually. So I don't think that settlement is different. I think many times we can reach in settlement solutions that are not completely legally justified, because the judge would say to the bank or to the, I mean, you should pay. And many times it helps to settle, even if by law there was not a clear justification. So it is a creative sphere. And as in negotiation, we can expect different outcomes, but not really expect that necessarily the settlement will make weak parties weaker, definitely because also they care about time, and the strong parties usually take advantage of it. We have more questions? Ettore,
Yes, is there some other question? There is another one of Daniele.
I have a question in Italian, but
it's in Italian.
Daniele, do you want to ask your question? Well, more than a question, it was the response. Yes, a response. It's a response to what the professor said. Anyway, I wish to thank her very much for this, the picture she's given us, because it helps us to understand a different system from ours, the Israeli system. But let's say on the risks that the parties run when there are less resources, the response of the professor, if I've understood correctly, is that she says in this case the presence of a judge instead of a mediator can be an element of guarantee, because it can help recognize situations of difficulty, of weakness of one of the parties, and therefore help them. So on this response, if this is what the professor said, if I understood correctly, I think that we should have trust in the sensitivity of the judge who deals with the phase of mediation, this attempt at conciliation, which is ongoing. Because, of course, every judge has his own sensitivity. Every judge is a human being, and so he can have sensitivity on one case, which is different from sensitivity on another. There is no discipline that can oblige him to take these aspects into consideration. Thank you.
Yeah. I mean, thank you. I think what I'm trying to do is to develop the regulation of this sphere and make it not only based on the judge and the individual response. And it is the same question about mediators, that do mediators respond the same? I mean, in each development of a new institution, a new process, usually guidelines develop. And I think there should be guidelines. There will always be some personal effect, but the sensitivity is sometimes, it's not something that is hard to detect when you have in an institutional party like a bank and a plaintiff. So there is an understanding of who is the weak and who is the strong, and the judge is working with this complexity, and he cannot really address them as equal, and usually it wouldn't happen also in the trial, and it wouldn't happen in the settlement. But indeed, it's a concern, and some judges will resist this process, especially because of weak parties. It is something that need to be studied. I don't completely deny the fact that there could be places in which weaker parties will be pressed to settle, but it is important to make it in the right way, with informed consent, and with letting parties know what is their interest, and with empowerment, and with the added values of the personal and human approach, and the institutional face of the judiciary as addressing people and not only claims. So I hope that if we do that, together with taking into account differences, we can reach a better place. And in any case, since we are there in the settlement hearing, at least in Israel, it's very important to rethink explicitly about this role. And in my perspective, important to insert conflict resolution education into this moment in order to make the most of it, including awareness of disadvantaged parties. So I'm sorry that we are all over my time limit. So
there is no problem.
So there is a question in Israel, therefore, is the preliminary hearing held by a judge other than the judge? No, so I said it is changed. The preliminary hearing, the pretrial, is heard by the same judge who decides later. It was in the past different judges, and then in order to make it more effective, the judge is actually putting together the prediction of what will be the legal outcome, together with looking at the conflict and advising the parties to settle. And this new terrain of discretion, judicial discretion, is very broad, because in Israel, the legal rules are sometimes given to some discretion, and you can insert policy and balance them. And it's not that you look at the book of rules of law, the law book, and implement the law. You use discretion. And there is a discretion now of the settlement hearing. So all of this together make the judge responsible for really a very important role of integrating those considerations. I think this is a very hybrid process, maybe problematic, but if we can learn something from it, both for mediators, both for judges, so we can take it with us and insert elements in it. In our practice, when I practice judges, I said, even if you take one tool and use it, I will be happy. And happily, one judge later wrote to a friend, not to me, so it was not to convince me, that she tried it and it worked. And she was so satisfied and happy. And she tried some elements of, mirroring the party, listening to the party, and it worked very well. So I think that it's a beginning. We are all dealing, both Paula, both me, with in certain legal education, also to the judiciary, to lawyers. If we work with all the system, I think there will be a chance that indeed mediation can also get the important role that it has, because everybody will understand what they cannot achieve in the court when there are records and what they can achieve in mediation. But if we don't do it, sometimes the court will be the main experience of the layperson, and this is sad. We don't want the court to be just an institution of efficient management in which there is no clear value. So thank you. This was a pleasure. At this point, I don't see everybody, and my Zoom is quite upside down, but the experience, most of the experience I really felt the people, I saw you, I felt that I managed to communicate with you, although I'm from afar, and my hope is that in the future, I will be able to come to Florence, be there in person, and meet with judges, with mediators, to really interact. Now I see all the faces again, so it's great. So I thank you, Paula, for this opportunity. I was supposed to be on sabbatical in the Firenze University and organize this training together with her, but this hopeful event means that we can still plan and we can still meet even on Zoom. And when we meet in person, it will mean so much more. I think that one of the things that this pandemic brought for us is to appreciate much better the real encounter. I hope that part of it was really also conveyed through the Zoom experience. So thank you.